So I can kind of type today. My hand hurts.
You have to do like the 3 finger.
Yes, I've been using 3 fingers to type on my left hand. And you know me, I talk with my hands, and that rush of air stings. So
so bad too.
I'm trying not to do too much.
So not to look at it.
Yeah, okay. I'll try and keep my hand out of sight.
I see it, I get bad phantom pains.
Yeah, so do I when I see somebody's cut. I'm like, so
bad.
I've been trying to get through this book for a while. And last week I was going to spend the entire week talking about this. And on Monday morning, I decided to slice some cucumbers in my new mandolin slicer. And the cucumber fell off the holder, and my hand kept going. And a chunk came out, and we put the chunk on ice, and I currently have 7 stitches. They hope the graft will work. We don't know. I'll find out Wednesday, so the next episode, maybe I can give people good news that I still have a full finger. But my left ring and pinky finger were sliced, and I couldn't handwrite at all. I could type with my right hand, and I'm left-handed, so this has caused a great deal of frustration for me over the past week. And then I was able to type with my other 3 fingers on my left hand, but it was still really hard. So today there's probably going to be some jerkiness in me reading stuff, because normally I like to type up the quotes out of the book that I've read, and because it hurt so much, I just would read page 21. And I've got a little Post-it note here of what I wanted to read. So there might be a slight pause where I go, oh God, where was I supposed to read? That's what that slight pause is, me panicking inside and then remembering where I wanted to read. So if you hear those pauses, that's why, because I almost sliced my finger off.
The curse of being lefties.
Yeah.
We're both lefties.
Yeah. We're just cursed from birth.
Yep.
Nothing is made in this world for us except for toll booths, and that's so people can take our money.
Exactly. Kind of makes you think, don't it?
Yes. Even think about it, if you've ever gone through the self-checkout at the local Walmart here, there is one self-checkout that's designed for a lefty.
I guess I never paid attention to that.
Ticks me off because it's always in use by a right-handed person.
And this is your daily rant.
So everybody likes murder, right?
And not lefties.
Yeah. Well, unless you're the one getting murdered, people love a good story. And today we're going to talk about the first murder in Scotts Bluff County on Storytelling on the Plains. I'm not going to do too many oohs and ahs because although there is some amusing stuff in this story, because again, nothing has changed in more than 100 years. So first I want to clear up a little matter. Originally, what is now Scotts Bluff County was part of Cheyenne County. And after lots and lots of squabbling, you ended up with several counties. You still have Cheyenne County today, but Scotts Bluff County became a county in 1888 along with Kimball, Banner, Deuel, and now a reduced-sized Cheyenne County. Mm-hmm. It happened during an election, and one day we'll get to that story because I don't actually know the story of how that all came to be, why they wanted to break it up, other than these are huge.
They're huge, yeah. I guess that would be my guess. Is there, how would you maintain all that back then?
And as we're going to get to in this story, this murder takes place in Minnetonka, and the murderer was taken to jail in Sydney. So from Minnetonka to Sydney, about an hour, little less, by car. So, we're talking huge distances, and my guess is that's why they wanted to break them up. I'm not totally sure. We'll have to do an episode on that someday.
Well, yeah, because didn't Wyoming own a bit of Nebraska?
Yeah, so did Colorado, and then everything got reorganized and shaped and.
Because I heard that's the reason why we have our little top part where we're in. Is that Wyoming just didn't want to deal with the with the local native population, so they just left it.
Yeah,
it's like Nebraska,
there you go. You guys can have it. So Scotts Bluff County and all these other counties officially formed on January 15th, 1889. If you go to the Scotts Bluff County Sheriff's Department website, it lists the first murder in the new Scotts Bluff County as occurring on June 30th, 1890, so we're talking 2 years later, 1/2 mile east of the Wyoming state line at a location about 3/4 of a mile south of the old Lyman High School building. On that day, John F. Knapp shot and killed Albert F. Pippick, who identified his killer by writing on an envelope with a sharpened revolver cartridge. W.H. Johnson acted as coroner, and Sheriff Milton Bile posted a $100 reward. Newspaper accounts heralded the event as a cold-blooded and premeditated murder and wrote, if he is captured by other than officers of the law, he will be likely lynched in short order. However, we are going to talk about another murder, which happened in 1888, and the trial happened in 1889, and I contend that this is the first murder in Scotts Bluff County. And I'm going to explain a little bit more, and then everybody can decide whether it is or not. Doesn't matter, because this is the one we're talking about. So this murder took place in the hamlet of Tabor, which became Minneterre. And at the time, Minneterre was in Cheyenne County, but we're not going to get bogged down in technicalities right now. When the murder happened, the dead guy's in Cheyenne County. When it went to trial, the dead guy's in Scotts Bluff County, just because the new counties were made. So y'all can nitpick all you want, but this is the first murder, in my opinion. So the murderer was John S. Arnold, who killed George Burton, a local homesteader. The cause was a dispute over wages. In a February 20th, 2020 article in the Star-Herald newspaper, reporter Jerry Purvis noted that when the counties were broken up, Cheyenne County figured that now that Minneterre was in Scotts Bluff County, they didn't have to pay for the trial. Ain't in our county anymore. The Scotts Bluff County residents were ticked and complained that because the new county had no money, they shouldn't have to hold the trial, but they had to anyway. And we're going to get into all of that in detail, and we'll come back to this being ticked in a little while, but just keep that in mind. This county is literally newly formed, and now they got to host a murder trial. And as you're going to find out coming soon, Arnold also didn't have money for a lawyer, so county had to pay for a lawyer for him as well. So they're footing the entire bill for this thing. So most of the backstory from this book, I'm going to be reading from this book, Reversed, The Arnold Affair, Scotts Bluff County's First Murder, by Robert G. Simmons, Jr. This was really hard to get a hold of. I happened to get lucky. There was a copy on Amazon, and then when it was delivered to me, it came from a business on Broadway.
Interesting.
So I'm like, dang. And I can't find it anywhere. I went looking for PDFs. I went to the Internet Archive. I don't think it's ever been scanned in anywhere. So I will probably never loan this book out because I don't want it destroyed.
Oh, absolutely.
It was so hard to find. So I'm going to read something from the memoir. Just give me a second here. Pages 11 to 13. So on June 23rd, 1888, George W. Burton, his wife Mrs. Alice D. Burton, and a Miss Phoebe Scott had been to Alliance, Nebraska, which was about 50 miles away by horseback from the scene of the events involved. About 6 p.m., they returned to the Burton sod house a few miles northeast of Minneterre, which was at that time in Cheyenne County, Nebraska. Soon after arriving home, Mrs. Burton saw George Arnold coming from the direction of Minnetonka. Mrs. Burton knew George Arnold. He lived 3 or 4 miles away, and he had worked for George Burton during May 1888. So, about a month before this day happened. George W. Burton was sitting by the stove in the southwest corner of the only room in his sod house, with his arms folded, his feet on the stove hearth, and his left side toward the door when George Arnold approached. Miss Scott and Mrs. Burton were also in the room. When Arnold came toward the house, he was carrying a stick about a yard long. I find this interesting that, this book was written in 97, and the guy chooses to say that he was carrying a stick about a yard long, instead of just saying he was carrying a yardstick. Anyway.
About a yard long.
Yeah. Maybe it wasn't quite a yardstick. Maybe it was an inch or two shorter. Who knows? Mrs. Burton said good evening to George Arnold. George Burton invited Arnold into the house. Arnold sat down on a trunk and said to George Burton, "Well, George, are you ready to settle?" "I am." At this time, the men started talking business, so Miss Scott left the house. She went out by the only door, which was located on the east side of the house. She went to wait in the log shed attached to the west side of the sod house. George Burton asked George Arnold, "What did you do with the horses?" "I worked them until they were ready to drop. I worked the 21 days at $20 a month. You owe me $11. "What did you do?" "I plowed." "What did you do with the corn?" "I fed it." "Fed it?" George Arnold then rose and drew a revolver and shouted, "I mean business." George Burton said, "Don't be frightened. Sit down. You can't scare me with that way, Arnold." Mrs. Burton told George Arnold, "Stop. We are going to pay you." George Arnold aimed the pistol at George Burton while Mrs. Burton was in front of George Burton. Are you getting tired of the Georges yet? The pistol failed to fire the first time the trigger was pulled. Mrs. Arnold stepped to the cupboard to get some money. Then George Arnold shot twice. George Burton went to the window, and Arnold shot the 4th time. We skipped the 3rd time. After that, George Arnold screamed to Mrs. Burton, "See, in my pain from nearly chopping my finger off, I didn't notice that till I just read it out loud." "God damn you, I'll kill you if you don't pay me." Mrs. Burton picked up her purse and emptied the contents into Arnold's hands. Mrs. Burton ran out of the room to see Miss Scott to get some money. Mrs. Burton shouted at Miss Scott, "Give me some money or he will kill us." Miss Scott handed Mrs. Burton some money. As Mrs. Burton turned and went back to the house, she passed Arnold coming out of the only door. Arnold said to her, "I finished him." Miss Scott also met Arnold as he left the house. Arnold told Miss Scott, "I'll learn a man to ask me what work I done." Miss Scott mounted her horse and went for help. Mrs. Burton went back into the house. George Burton was lying over the stove. He was dead. George Arnold walked to the home of Wellington Clark, who lived nearby. He arrived at Clark's house at sundown, and Clark offered to take Arnold home. When Arnold got into Clark's wagon, Arnold said to Clark, "Mary told me not to do what I have done." Then Arnold said to Clark, "What is the penalty of murder?" Clark told him, "Hanging." Arnold said, "Clark, I want you to be there." Then Arnold told Clark about Burton owing him and asked Clark to see that his family got the pay. As Arnold got out of the wagon, Clark asked Arnold what he had done. Arnold said, "I killed George Burton. I shot him 4 times. I'll learn a man to pay me and call me a son of a bitch." Theo Harshman, deputy constable, went with A.M. Fairchild and others to arrest George Arnold the same day. Harshman called Arnold to the door, but he did not come. Harshman then entered the house, and Harshman saw the gun Arnold had. Arnold wanted his wife to keep it. Fairfield took the gun and delivered it to the sheriff. Arnold was taken to the Cheyenne County Jail in Sydney, which was about 70 miles away that same night. So that's the details, mostly, of the murder. The trial and everything that happened after he was arrested is actually a big part of Nebraska history that people don't really realize. So we run into the same the name thing again, and I'm just going by last name, so I'm not going to call him George Arnold. He's Arnold. His lawyer's name was George. There's just too many Georges, so everybody's getting last names here. So Arnold kills Burton on June 23rd and is taken to jail in Sydney. Arnold is arrested, but he didn't make his first court appearance until July 23rd, 1 month later. So he's sitting in jail for a month. He told the court he was indigent and asked for representation. He requested a specific law firm, and the court approved. And this is all detailed in the book, but I'm not going to sit here and read all 79 pages of this little book. Y'all need to try and find it online, because you're not going to borrow my copy either, unless I stand next to you while you're reading it, and then you will have to hold it a certain way. Yeah, and if you turn the pages wrong, I'll yell at you, so it's just best to go find your own copy. On July 28th, Arnold was brought into court again. So he comes out on the 23rd for his first court appearance and then goes right back to jail. And then 5 days later, he's brought into court again. His lawyers file a plea of abatement, and normally this plea is made when a court doesn't have jurisdiction.
Oh.
Robert Simmons, who wrote this book, said he couldn't find any evidence of the basis of the plea. It could be, he said it couldn't be the venue, because at that time, Minnetonka was still part of Cheyenne County, and the vote wasn't held until November and went into effect in January, so the murder happened in Cheyenne County. Simmons speculated a couple of reasons why, including Arnold being in jail for so long and stall tactics, they know they're not going to win on the abatement, but let's file it anyway. It's a stall tactic. But he couldn't find anything concrete other than the county attorney filed a demurrer to the plea. I learned all kinds of legal terms reading this dang book. So that's basically the county attorney legally saying, yeah, so what? And after some bickering back and forth, the judge overruled it. So, maybe it was just a stall tactic. So 2 days later, on July 30th, 18 people gave their bond at $500 each that they would appear as witnesses on the first day of the next term of the court. And we'll come back to that because there's a D.D. Davis that's going to be involved that there's still question today about. I found it interesting that 18 people were bonded at $500 each that they would show up as a witness. That's a crap load of money in 1889. Mm-hmm. I think I was going to look up, again, I'm going to blame my bum finger that my brain didn't work right. I was going to look up money, how much this money is in today's money, and I forgot. But it's got to be several thousand, at least. So anyway, we'll come back to that. Just remember the witnesses. December 6th rolls around, and the indictment is read to Arnold in court. Imagine that. You're in 5 months in jail before you know the specific charge. Now, granted, he knew he murdered the dude, but he sat in jail for 5 months before the court read him the charge. So we're not talking a speedy trial here. So let me read to you what the court read to Arnold. It charges that George S. Arnold on June 23, 1888 in Cheyenne County, Nebraska, there unlawfully, willfully, feloniously, purposely, and with deliberate and premeditated malice did shoot off and discharge a pistol, called a revolver, loaded with leaden bullets, which penetrated the said George W. Burton, which caused 2 mortal wounds, from which the George W. Burton instantly died. And I just read that because...
Look, that words.
Yeah.
They're very beautifully written.
Yes. Arnold pled not guilty. The next day, he filed a motion for a continuance. So Simmons did more research and found nothing until June 3rd, 1889. And I'm going to read you that quote here. Man, it's still hard to turn pages with my finger. Dang. So it's little tiny writing. It was made apparent to the court by the affidavit of the county attorney of Cheyenne that the crime alleged to have been committed by the defendant was committed in the territory now embraced in the county of Scotts Bluff, Nebraska. That said county is duly and legally organized and properly officered, and that a term of court is fixed for said county July 15th, 1889, and that said alleged crime was not committed in Cheyenne County. It is therefore ordered by the court that said cause be and the same is hereby transferred to said Scotts Bluff County, Nebraska, for trial at the next term of the district court in and for said county, and the defendant remanded to the custody of the sheriff of said Scotts Bluff County for safekeeping. So all those words basically say, yeah, the murder wasn't committed in Cheyenne County, it was committed in Scotts Bluff. You got to go to Scotts Bluff when they have court in June.
So it did happen in Scotts Bluff County.
That's what they're saying. I think there was a lot of Cheyenne County just didn't want to pay for it. So your case gets moved to Scotts Bluff County. So Jerry Purvis also wrote in his article, the first murder trial for Scotts Bluff County was held in the upper floor of the Gearing and Sayer building, the first brick structure to be erected in the county seat of Gearing. It was at the corner of Euclid Avenue and Lincoln Street. Today, the location is 10th and M. What's on 10th and M today?
Not sure.
A little old building called the Civic Center.
Oh, okay.
Where I think it's 10th and M. Yeah, I think that's 10th and M.
I don't know Gearing Streets as well as Scotts Bluff.
Yeah, now that I say it, I'm like, oh my God, I know Scotts Bluff better. Anyway, go to 10th and M. That's where it was. On July 16th, Arnold appears in court. All the same attorneys are present. His indictment is read out loud again. Arnold again files a plea in abatement for defects extrinsic to the record. On August 18th, the Scotts Bluff County attorney said it should be sustained, and the court agreed. I don't know what the heck any of that means, and I really didn't want to go into the legal weeds with this. So all you legal people out there, you're all nodding your head going, what? Because basically the county attorney was like, what? So, yeah, it's another stall tactic. So basically the Scotts Bluff attorney is saying the abatement wasn't legit before, but it kind of is now because this is a new county. We don't know for sure, though, because the details weren't preserved. And I think they should have been because this is kind of important, but I think they also didn't realize that this case would be cited in the future and would be as important as it turned out to be. I would have thought that you would have thought that would be it because it's not just a simple change of venue. It's like you're being charged with murder in a county that didn't exist when that murder happened, and the county that existed when that murder happened doesn't exist anymore. So how do you determine jurisdiction? To me, that's a precedent-setting thing.
Yeah, because what are you going to do? Just let him go?
Yeah. And Simmons did write several times in his book that he did try and find more information, but there were times where it was lacking in the court records. Like he looked at the court records and there's just nothing there. So when the original abatement was filed, it's just noted, the judge's note says that there was some bickering back and forth, but nothing was recorded of what was those bickering words, whereas today you have all of that. So that's where we get some of the gaps here because it just doesn't exist.
Makes sense.
So we don't know if Arnold was let out of jail, but I don't think he was. Before the decision was reached, there was an order to get some grand jurors, and on August 21st, the grand jury was selected and sworn in. They delivered their indictment that day and served Arnold. Now, think about today. You seat your grand jury today. They all going to look at a case today? No. But they did. They were selected, sworn in, and then delivered their indictment. So to me, I hear the word railroaded in my head. Granted, he is a murderer, and he admitted he killed this dude, but you still have to follow the law.
Yeah.
So Simmons brings up a good point in the book about how all this was done in one day, which I also was like, what? I think it was all done behind closed doors. I've literally seen things like that happen with city council when I covered it for the paper. You can't prove that it happened because no one on city council will be like, oh yeah, we met. They're not going to admit it, but because certain things take X amount of time that it didn't. Yeah, y'all were talking. Even though it's illegal, we know what you guys were doing. And to some extent, Scotts Bluff is still a good old boys network town.
It is.
So that stuff happens all the time here. Until this point, everything was taken forever to do, and then bam, here you go, indictment. It just doesn't happen that quickly. You and I know from working at the shelter.
Yeah, we do.
Kid gets arrested, comes to the shelter. Court date is in a month. He shows up to court. He's there 5 minutes, and okay, come back in 6 weeks.
Mm-hmm. It takes time.
It takes like 4 or 5 months, and then the charges are dropped because they were BS charges to begin with. And then in the meantime, this kid has been in a shelter for 4 or 5 months, not being able to be home with his family. Now, granted, sometimes the kids that came were guilty of what they did, but we still got our fair share of kids that shouldn't have been there, but because the process is
into the system.
Yeah. So this indictment was extremely similar to the first one in Cheyenne County, with the exception that it tried to explain the murder happened in Cheyenne County, but that it's not Cheyenne County anymore, it's Scotts Bluff County, so that's why you're charged here. So let me flip over here to page 20 in the book. On August 22nd, 1889, the defendant moved to quash the new indictment for 3 reasons. The indictment purports to be, on its face, an indictment presented by a grand jury of Scotts Bluff County, state of Nebraska, and charges the crime alleged therein to have been committed in the county of Cheyenne, Nebraska. The indictment does not charge the defendant with having committed the crime therein alleged within Scotts Bluff County aforesaid. Said indictment is ambiguous and by duplication alleges the crime therein set forth to have been committed in the county of Cheyenne and also in the county of Scotts Bluff. I know a guy's dead, but this is hilarious. Because he's basically saying, you're trying to say I killed somebody in a different county and charge me in this other county and then say that it occurred in this other county too, and that's not possible.
So, haha.
Yeah.
So murderers, next time you want to get off of something, you have to wait till the counties change.
Yeah. Make sure you commit the murder just before an election where the counties are all going to split up. So my thought there was they're trying to get him off on a technicality because no court legally, if you want to technically look at it, what court can prosecute him?
You have a court that can prosecute him.
Yeah.
And so both don't want to prosecute him.
Yeah, neither one of them wants the expense of this because they know it's super expensive. So the next day he files another plea in abatement. In it he says there were not enough electors who, excuse my typos there, Connor, blaming my bum fingers again. There were not enough electors who voted for the proposal to detach the area from Cheyenne County and create Scotts Bluff County, that Cheyenne County still exists and the defendant is entitled to be tried in Cheyenne County. The defendant quoted parts of the Nebraska Constitution. So he's still arguing this thing, and then he starts citing the state constitution. This plea also included a bit where he says he never filed a motion for a change of venue, the court did, and that he's being denied life, liberty, and property without due process of law. And he's right in that. He didn't file for the change of venue, the court did. Okay, I just want to get my page straight here. Then in the same new plea abatement, there is the allegation of constitutional provisions against ex post facto laws, making an act which had already occurred a crime, impairing the obligations of a contract and the grant of special privileges. There is another charge in the plea which should be more specifically mentioned. It alleges that D.D. Davis, whose name was mentioned earlier as being a witness, put up a bond to appear in Cheyenne County, did, as deputy clerk of Scotts Bluff County, along with the deputy sheriff, draw the names of 24 men for the panel which was to be used in selecting the jury in this case. The names of the proposed jurors were set out. The plea in abatement also alleges that the name of D.D. Davis was endorsed as a proposed witness in this case. It is also alleged that D.D. Davis was the brother of Alice Burton, the widow of George Burton, who Arnold killed. There's also another thing in here about D.D. Davis, that as deputy clerk basically, picked the jurors, and that D.D. Davis, was prejudiced against Burton because it was his brother-in-law. And then the charges just go on and on for 2 more pages, and I'm not going to read 2 pages of this, but it's all kinds of your basic legal stuff where you're like, this wasn't done right, this wasn't done right, this wasn't done right, and why did Davis have anything to do with this? Why did you let even this possibility of impropriety step into here? So this was all done on the same day. We're still on the same damn day. And these are complicated documents. They're written longhand, and there weren't any typewriters out here. Maybe there were some. I went and looked. First, I know for a fact everything was written longhand from start to finish in this case. I went and looked. The typewriter was introduced in 1874, except they didn't come into common use in offices until the mid-1880s, and we're at 1889 now, and we're in extremely rural Nebraska at that time. Even today, we still are behind the times in some things.
We just got the typewriter. Yay.
Yay. Man, wait till they learn about flat screens. But you're talking at a time where these things are not going to be heavily invested in rural Nebraska at this point in time. And all the legal documents are handwritten. So most of these things are anywhere between 5 and 15 pages handwritten.
Yuck.
And they're all dated the same day. So the plea is overruled, and then on the 26th, a demurrer is filed by Arnold and is overruled immediately. So right after, and I mean right after, Arnold tosses another 4-page longhand plea in bar. So he's already got another thing ready. He knows that this demurrer that he's filing is going to get chucked out, and he's like, oh, well, here's something else. And it's called a plea in bar. And I mean, seriously, someone needs to take this case on and make a freaking movie out of it.
Right? I'm just going to keep going, guys.
So the biggest allegation here is the state of Nebraska ought not further to prosecute said indictment against him because at the December 1888 term at the District Court of Cheyenne County, Nebraska, held in Sidney, in said county, he, the said George S. Arnold, was indicted by the grand jury of said county on said charge that he was duly arraigned in said court on said indictment and pled not guilty hereto. That after having pled not guilty and being placed on trial was lawfully acquitted and being discharged of the offense charged in said indictment. So it goes on for 2 pages, motion after motion after motion. It's funny at first, and then I was just like, oh my God, this is just absolutely ridiculous. But basically what he was saying was that because they moved it to Scotts Bluff, he was acquitted automatically in Cheyenne County.
Legal mumbo
so
jumbo.
now this is double jeopardy, and he can't be tried again. That's basically what his argument is. So the people in the court here in Scotts Bluff County also forgot it was Labor Day, so they were like, oh no, we can't do it on this day, we have to do it on this day, and they wrote that. They don't write details about what the lawyers are bickering about, but they write details that they forgot a damn holiday. Mm-hmm. So my first thought was, how do you forget that? And then I went and I looked, and Labor Day was first suggested in the early 1880s. So say 5, 6 years before this date when he's in court.
Still new. Get used to
it. There's some conflicting info out there about who first proposed it. Who cares? Both proposals were 1882, so I'm not here to talk about Labor Day and when it came to be. Oregon was the first state to recognize it in 1887 as an official holiday, and by 1894, 30 states were recognizing it. I couldn't figure out. I did a quick search, and I kind of honestly didn't care. I don't know when Nebraska decided they were going to be, one of the ones. And President Grover Cleveland signed a bill into law June 30th, 1894, making it a holiday. So this is all still relatively new. So I'm going to forgive the folks in the courthouse for not remembering a new holiday, because the people I know now can't even remember when Juneteenth is. So there we go. Simmons noted in his book that the Gearing Courier had yet to print a single word about the case. The first mention was in the September 12th, 1889 issue. So you're more than a year from the murder. And while we want to criticize the paper for this, Sidney is 80 miles from Gearing. And as a reporter, I've gone to Cheyenne County Court in Sidney to write stories, but I got a car. And this is 1888 and 89. But of note, A.B. Wood, the Courier's owner, didn't change the policy of going to the courthouse at all until the start of this trial. So until then, he didn't even go to the county courthouse here. At some point, and we don't really know why, but at some point he decided, I'm going to go, we're going to go to here and report on this. And then I have filtered in here some of my questionable takes on that the newspaper did. We'll get to those. So the trial began on September 7th, 1889, which was a Saturday. And it continued the next 2 Saturdays and finished on September 17th, a Tuesday. So just think about that. Your court dates today they're not going on Saturday. Very, very, very rarely will you have a court
on Saturday.
And this just seemed to be a normal thing. So as to the jury selection, Simmons wrote, sorry, that's the other thing about getting old, man. I used to be able to read here and it's all blurry, so I got to put my hands out like an old person. There is a legal presumption sometimes used which provides that it is presumed that a public officer acts correctly until it is shown that he did not act correctly. The record we have shows the allegation that D.D. Davis did not act correctly, but there is nothing to show that the judge did not act correctly. Therefore, it would appear likely that the situation caused by D.D. Davis helping to select jurors, if it ever did exist, did not exist through the final selection of the jury used in the trial. So they're still arguing over, was he biased because he's the supposed brother-in-law? So Mrs. Burton and Miss Scott testified. And I do encourage people, if they can get a hold of this, Simmons goes into great detail about everything that happened, both sides of the case. And it is a good book. It's a quick read. But I'm not here to go through all 80 pages. And I keep changing the number. It is actually 79 pages long. It doesn't take long to read it, but Mr. Simmons here did a really good job getting the details for me and saved me a whole lot of heartache.
So I don't have to find it myself.
And that's what I would have had to do. And he thanks people at the end of the book, and he went everywhere. He went to the courthouse. He went to sheriff's office. He went to Legacy, the archives. Well, at the time it was still Farm and Ranch Museum. But he went to multiple places to find this information, and it's still not online. It was difficult for me to find anything online about this.
Interesting.
So Mrs. Burton and Mrs. Scott's recounts of the night were extremely similar. The defense argued that there was no way Miss Scott could have heard anything because of how sod houses are built. And again, I'm going to credit Mr. Simmons here with the book. He has a drawing of the house, which I forget which person involved in this drew the outlay of the house, and it explained how if you're in a sod house, you can't hear what's being said inside if you're outside. And remember, Miss Scott was in, what was it, the shed that was made of logs and attached to the sod house. So you kind of have a double wall there. So the defense was basically saying she couldn't have possibly heard this. Wellington Clark, the guy who offered to take Arnold home, also testified. Theo Harshman, the deputy constable, also testified about the arrest of Arnold. And, that's typical stuff for trials. I think we're going to have to close the cellar door because I can hear the microwave now. Y'all can hear the sounds of my house during a podcast because we're professionals. A.M. Fairchild testified that he dug the bullets out of the sod wall and the ceiling and kept them until the trial. He also testified that Dan Davis was with him at the time. So Simmons even questioned in the book, is the D.D. Davis mentioned in all the documents Dan Davis? We're not 100% sure, but it seems to match up. Everyone else who testified for the prosecution basically said, yeah, I saw George Arnold earlier that day and he seemed normal and okay. Because the prosecution is basically saying he was fine till he shot this dude. And George's side is later going to be like there was something off about him that day. Typical murder trial stuff. So there was also some concern about the legitimacy of tests over what could be heard that night because the house sat empty after Burton was killed and had deteriorated considerably since then. Simmons goes into great detail about this, that they basically, I mean, yeah, that's great that they went back to the house to try and recreate it, but the house had sat empty for a year, and it's a sod house. Yes, and he also describes how sod houses are made and that you constantly have to repair them. And so it makes the defense did their job in questioning, are those tests or even legit? Because that test should have been done like within a few days of Burton being killed. So I'll give the defense credit there, man. They did their job. And then I'm going to read here again from the book. This is another thing you don't realize till you bung up your good hand. Turning pages in a book is awkward for me. And I just tore it off and forgot. The state called 2 doctors to testify concerning the cause of death. In the murder case, the state has to prove that the death was not a natural death, but resulted from the criminal cause alleged in the indictment. Dr. Burney, who resided at Sydney, examined the body of George Burton on June 25th, 1888. Ooh, there's a typo in the book. It says 1988.
Oh.
Ooh. He testified that there were 2 bullet holes in the upper and outer part of the chest between the 3rd and 4th ribs, and one on the back of the neck left of the median line. He testified, found this ball in the neck and this in the rafter. The chest wound was of mortal nature, and the chances would have been against the deceased as to the neck wound. And I don't know if that's a typo in the book or if that, because he has it in quotes, so he may have spelled deceased wrong. On cross-examined, Dr. Burney refused to state the probable effect of the wounds received. Dr. Georgia Arbuckle Fix, who I have all the notes ready to go to start working on a story about Dr. Fix, of Gearing, and then this says in parentheses, a lady doctor whose name appears in reports of many events in Scotts Bluff County early history. It just cracked me up. He wrote this book in 97, and he's calling her a lady doctor. Anyway, Dr. Fix testified. She was present at the post-mortem, and she saw the body before it was moved from the sod house after the shooting. So I find that kind of cool. Dr. Fix went out to the house and examined the body. And that's just because I'm a girl, and I think that's cool in 1888. She testified to the same wounds as Dr. Burney. Dr. Fix concluded death would have resulted from either wound. So I just read that because I like Dr. Fix. I think she's kind of cool. And she's in... Bless you. Bless you. And she was there at the first murder. So I don't know. It's just a dork thing for me. So now you all get to experience it too. So in Arnold's defense, the same A.M. Fairfield testified. So Fairfield testified for the prosecution. Now the defense has brought their case, and he's testifying for them too, which I thought was odd, but I don't follow enough criminal trials to know if it's odd or not, because normally they just cross-examine. Yeah, so I don't know. He said he drew the plan and layout of the house and examined the Burton's wounds, as well as observing gunpowder residue on the neck and the breast. Fairfield admitted he didn't give all the evidence to the defense. So now you just gave the defense something else. Yeah. Y'all are withholding evidence. Yep. Fairfield also voluntarily said, after he had said, yeah, I withheld evidence, it was one of the most cold-blooded murders I have ever heard of, and that the damn son of a bitch should be lynched to save the county expense.
Just kill him.
Yeah, just kill him. You're a great witness, dude. You're setting up our appeal. Thank you. Another witness, W.C. Tabor, said Arnold's eyes were bloodshot and glassy, like he had been working all day, while others said he was acting differently that day. I think we can see where the defense is going with this. They questioned the credibility of some of the defense witnesses, particularly Fairfield. 9 witnesses testified against Fairfield's reputation, and they all said it was bad. Like, nobody had a good thing to say about this guy that admitted that he didn't give proper evidence and then called the defendant a damn son of a bitch who should be lynched. Oh, I wonder how many more times Fairfield testified in court after that. So I'm going to read a little bit here from what was written in the Courier. On Monday, the 16th of September, 1889, the arguments to the jury were commenced. First, there was the argument of the prosecutor, Richardson. The Courier reported his argument as follows. He opened by congratulating the jury, the court, and above all, the people who have the burden upon termination of the case. He asked if the state had not proven every allegation that George S. Arnold had killed George Burton as charged in the indictment. Does this remark to Wellington Clark, Mary told me not to do what I have done, not convince you that his deed was premeditated? As to his sanity, was it not natural that the enormity of his crime would overpower him, cause him to act incoherent? Are not the very witnesses they sought for contradiction themselves contradicted and impeached? Yeah, you're getting away with editorializing here because you're saying, oh, I'm just quoting the prosecutor. Mm-hmm. But you're framing your reader's point of reference of who this dude is. You're painting him in a certain way. And I can tell you from working at the Star-Herald, I know one particular person who has done that, and I am still bitter almost a decade later that happened. And then when the Courier reported the argument for the defense, it was not, it was just here's the facts. And it's very long. It's like a page long. I'm not going to read it. But even Mr. Simmons here was commenting without a space for even a paragraph or a break in the line. The Courier editorialized, then said this. And then, so the Courier was basically writing, this is what the court documents say. And then they're editorializing. So it'd be like, this is what the defense lawyer said, but he's a load of crap, yeah. and they're just putting it right in the story. Mm-hmm. I don't want to say it was another time. It was shoddy journalism, mm-hmm. because even then, yes, there was yellow journalism. There's always been yellow journalism, but this is supposed to be the Gearing Courier. It's the paper of the town. It should not be this. And it happens, and it still happens. I try to defend people when they were not doing that, but I have seen it happen. And the one case that I'm particularly upset about, it affected me directly because I was asked to go and take notes. Mm-hmm. I went and took notes, and then someone else pulled seniority, took my notes, wrote the story, made the defendant look like garbage. I mean, granted, the defendant was guilty and was going to do some time, and I'm not going to get into that case, but the person who took the story from me mm-hmm. wrote it and made that person absolutely horrible. Mm-hmm. When I came home, I said to Paul, please look at my notes. And I said, now go read the story that's online. And he goes, are you kidding me? And I go, yeah. And I don't have a say in this. Mm-hmm. I should have written that story, but that person had been portraying the defendant terribly. I went back and looked at the previous stories as that person had followed the case, and it really made me angry. So when I saw this, it made me angry again. Yeah, the dude's guilty of murder. He admitted he murdered the guy. He needs to go to jail. Y'all don't need to railroad a guilty man. Mm-hmm. Just stop. So the defense tried a number of tactics, including insanity, and then the jury got their instructions and went off to deliberate. They returned a verdict on September 7th at 7 p.m. According to the Gearing Courier, they deliberated a little more than 2 hours. So, today, if we're getting close to 5 o'clock, the jury's not even getting their instructions till tomorrow. Mm-hmm. They're not going to get their instructions and start deliberating today. And then Simmons questions, what did everybody do? Because everything is so far away. The judge can't go home. He's got to listen to questions. And then the verdict, as set out in the court transcript, says, we, the jury in this case, being duly impaneled and sworn, do find the defendant not guilty of murder in the first degree as he is charged in the indictment, but do find him guilty of murder in the second degree. Afterwards, to wit, on the 17th day of September 1889, said defendant George S. Arnold filed a motion for a new trial. So immediately, the verdict, and that's common. That's common today. You're guilty. We file an appeal. You just get that motion in right away. It's denied immediately. So they're not even going through a process. Just, you're denied, sentenced to 49 years and pay restitution. And Simmons didn't go in too much about what the restitution was, and I don't know how you're going to pay restitution in the jail or what even the restitution was for. Do you have to pay X dollars the rest of your life to support the widow? Was a life worth X dollars? It didn't say. So the next morning, the sheriff begins his journey with Arnold to Lincoln. Simmons also didn't say how he got to Lincoln, but I'm assuming horse. I don't know. It's 1889. They're not driving a car there. The Courier, I think, also acts shady here. They report the verdict and its details in the September 9th edition. But in the same edition, they write a glowing review of the prosecuting attorney, as well as a separate comment complimenting the judge. No.
Yeah, that's a little...
I mean, the most you can say today would be the district attorney did his job, covered all the topics he needed to cover. Mm-hmm. The judge was fair. That's about all you can say as a proper journalist today. You can say things like, every time the defense objected, the judge threw spitballs at the defendant. You can say things like that, but you can't write what they wrote. It just, I don't know, it just really, really bothers me because I took pride in that I was objective, except for when I wrote my columns, because I wrote a column to make a point, so I have to make my point. But in every story I wrote, I tried to be as objective as possible, and they just weren't. So Arnold appeals his case. It gets up to the Supreme Court in Nebraska, which said Judge Church made errors and reversed and remanded the proceedings and ordered another trial. The appeal was filed September 3rd, 1890, and decided on September 17th, 2 weeks later. So think about that as well. That was a very quick amount of time, because if I'm found guilty of murder today, it's not going to take a couple of weeks for the state Supreme Court.
No, it's going to take a while. If they decide to listen to it at all.
So in the book here, the petition and error list had 42 assigned errors for the Supreme Court to read. And it didn't say how they decided in each of the 42, but they decided enough that the judge made enough errors that, he wasn't getting a fair trial. And Arnold was still in custody this whole time. So from the day of the murder till the day of the Nebraska Supreme Court decision was about 4 years. And as you can imagine, it was super expensive. Today, you're looking at millions. I'm thinking like 3 to 5 million easily.
Easily.
And like I said in the beginning of the story, the residents of the newly formed Scotts Bluff County were ticked. So they literally formed January 15th, and in July they had their first county court trial. So 6 months later, and they're supposed to foot the bill for this. So they were ticked. And I was being nice with ticked because I knew I had to swear a couple of other times, but they were really ticked. They didn't have any money for something like this, yet they had to pay for both sides. According to Simmons's book, the expenses were $7,495.73. The average monthly wages of a farm laborer at that time was $20. So the other thing I want to point out that I am not getting into, the prosecuting attorney's last name was Richardson. There was Mrs. Richardson that was a lawyer that everybody thinks was probably his wife. They were kind of estranged. There was some kind of argument in the courtroom over some things that were said, but nothing was detailed, and she spoke directly to the jury, and there's a question about should she have been allowed to do that. She's the one that eventually goes to Lincoln to lobby the legislature to pay for this. Oh. So going back to Jerry Purvis's article, the residents are angry. They don't think it's fair. Cheyenne County refused to pay for any of the costs, and the county lobbied the legislature for the money, which was refused for 2 sessions and then eventually paid. And Mrs. Richardson was the one that went to Lincoln that did the lobbying. And then she also tried to get the county to pay for her expenses while she was there, and they were like, yeah, no, we're not doing that. Again, if you can get a hold of this book, it's detailed as best as it can be in this book. In 1902, the Courier is still ticked about this. So you're 8 years later, they're still ticked about the money, and they wrote, "It was found that, by some trickery, the Arnold indictment had been foisted upon the docket of the new county." So they're still angry. They're like, yeah, they found legal ways to dump this on us. I would say if A.B. Wood had done his job as a newspaperman to begin with, he would have known about that from the start, and he should have been writing about it. But his Gearing Courier was silent on the matter. They didn't write anything till the trial started, and all this BS was going on before it started. He had to have known about it. The people I know in Gearing that are gossipy as hell, it was 10 times worse. And he's the dude who owns the paper. He knows what's going on and just chose not to do anything. So let me read you this little bit again. Sorry, really trying with the fingers here and getting better. So the Courier wrote, "This trial of the Arnold case lasted on and off for several months and cost a great deal of money. Just about at its close, a proposition to bond for $15,000 was submitted and carried by the county. Later on, however, a movement was inaugurated to secure reimbursement of the costs of this trial from the state. At the legislative session of 1893, a bill, House Bill Roll 278, was passed appropriating the $74,000, the amount computed by County Clerk B.F. Gentry as the actual expenses in the trial of Arnold, and this amount was paid over to the county treasurer Ed Sayer on June 21st, 1894. He was compelled to mandamus the state editor to secure it. And I forget what a mandamus is. Before Scotts Bluff County was paid the amount appropriated by the legislature to reimburse the county for the expenses of the Arnold trial, the state auditor refused to pay the amount appropriated. A mandamus proceeding to force the state auditor to approve the appropriation was brought by the county clerk of Scotts Bluff County." And then it goes into detail about what Mrs. Nellie Richardson did, and it's like almost 3 pages. So we're not going to get into that, but she went and lobbied for the county and got the state to pay for it. So thank you, taxpayers of Nebraska, for paying for the first trial, murder trial in Scotts Bluff County. There is also an entire section in this book about how it all got paid, what happened, who was involved. I don't want to get into that because I just want to stick with the murder, but there's lots and lots of shenanigans and begging and pleading and lobbying and all the legal stuff in this book. It was really starting to do my head in. And on January 4th, 1894, the Supreme Court in Nebraska reversed the case and remanded it, presumably for a new trial, but no one seems to know what the reasoning was. So I'm going to read one more time here. We have now reached the time for the solution of the puzzle presented at the beginning of this discussion to determine which of the many grounds raised by George Arnold's attorney was the basis of reversed and remanded. The Arnold case was not reversed and remanded on the matter of venue. It was not decided on the matter of the form or content of the indictment. It was not decided on the basis of an error in selecting the jury panel or the jury. It was not decided on the basis of admission of evidence or refusing to admit evidence. It was not decided on error of law occurring at the jury trial. It was not decided on the basis that an instruction to the jury was incorrect or a requested instruction was not given. The case was decided on the matter of an unfounded allegation of double jeopardy, i.e., the constitutional provision prohibiting a person from twice being tried for the same offense. You probably do not see where double jeopardy is involved. Arnold, at the time of his arraignment, August 26, 1889, offered to the indictment against him a plea in the bar as follows. And it goes into where he gave his plea. I'm not going to read that. And then the Supreme Court recited a section of the Nebraska Criminal Code concerning a trial of the factual issues raised in a plea in bar, which quotes a portion of the statute concerning issues on a plea in bar as follows: and on the trial of such issue to a jury. So all this confusing crap, the Nebraska Supreme Court basically says y'all never decided where he was supposed to be charged. You didn't take care of the stuff in Cheyenne County before he moved to Scotts Bluff County, and y'all need to go back and do it again. And it's not double jeopardy. Or it kind of could be, but y'all didn't do everything right to begin with, so you need to go back and do it again. Which is really, really confusing. And again, my head hurts reading legal stuff. Mm-hmm. So thank you, Mr. Simmons, for dumbing most of it down for me. So it gets a bit confusing for me because Arnold is supposed to get a new trial, and Scotts Bluff County wants money for this new trial, so they want money again. And the court says, he's remanded, but there's no indication of what that was supposed to mean. So do we really have to give him a new trial? They're happy to just leave him to rot in jail. So the Scotts Bluff County Commissioners concocted a plan with Lancaster County, which is where the prison's at, to get Arnold tested and sent to an insane asylum. And they go, don't worry, Scotts Bluff County, it's not going to cost that much money. So they do that. They get him sent to an insane asylum, and it costs Scotts Bluff County $100. $100. That's what a dude's life is worth. Granted, yes, he needs to go to jail. He murdered somebody. But they've done all sorts of bad things throughout this stupid trial that... Of
course, the asylums back in the 1800s weren't much better than jail. Sometimes they're a lot worse.
Yeah, so. I would have rather stayed in jail. So the Courier reported again that Arnold is insane, and he's been transferred from the penitentiary to the asylum. And I don't know if you want me to read this whole big long passage. He was they basically laid out the facts. Yes, he's been granted a new trial, but hey, he's in an insane asylum, so no new trial, which is BS. That's how they got around.
They didn't want to pay for all that again.
Yeah. So that made me angry as well. So this case has actually been referred to in 6 other opinions in the Nebraska Supreme Court and once in a U.S. Supreme Court opinion. They all concern the waiver of a jury for a trial. There are also other tangential. There are other cases arising from this case, but I just wanted to stick with the murder and not get into all the legal maneuverings. But it has been cited in 6 cases in Nebraska, 1 U.S. Supreme Court case, and many other smaller cases that didn't reach their state levels. George Arnold was sent to the asylum in Hastings, where he remained for a number of years. Mr. Simmons was under the impression he may have stayed there the rest of his life, but Wood later wrote that he had been released through some process or other, and Jerry wrote about that in his article, so at some point in time he was released. Jerry also wrote in that article that Arnold then headed back west to the valley and was last seen in Alliance before disappearing. Writing in his 1938 book, Wood said both he and County Clerk Ben Gentry agreed that Arnold had never been heard of since and had probably long since passed on. So he got out, came back here, and then disappeared. As to that other murder that the sheriff's office says is the first murder, that dude just basically disappeared, and there's been speculation over the years that they kind of let him get away because he literally murdered this person a year after this case went to trial. And they're like, the county doesn't have money for murder trials. So they think they basically just let him disappear into Wyoming, and that was it. So,
or lynched him.
Yeah, one of the two.
Yeah.
So, in my opinion, yes, this probably was the first murder in Scotts Bluff County. But if you want to get nitpicky and technical, it was in Cheyenne County. It's up to you. I go with Scotts Bluff County. Mr. Simmons, who wrote the book, goes with Scotts Bluff County. And don't murder people. It's not good to murder people, and it's expensive, and no one is happy.
No.
So we will see you next time when hopefully we'll have a happier story than people getting killed and shafted by the law in newspapers. But for anyone who thinks that newspapers are always fair, they are not. And I just kind of got a personal beef with A.B. Wood because, dude, you
such a jerk.
Yeah. So anyway, y'all have a great week or weekend or day or whatever when you're listening to this. We'll see you next time. I'm Irene.
And I'm Connor.
And this is Storytelling on the Plains.